director of the Dullah Omar Institute, and we are hosting this webinar together with the South African Local Government Association. And I'm going to hand over shortly to the moderator, Professor Nico Steytler, but just a few words before I do so is just the background to this meeting is a number of changes that are being suggested to the legal framework governing municipalities, particularly municipal governance at the political as well as the administrative levels of municipalities. In Parliament, there's Municipal Structures Amendment Act that has already proceeded quite a bit through the National Assembly and is before the NCOP. There is a Municipal Systems Amendment Bill in Parliament being debated in the National Assembly. And all these changes will, of course, affect the way municipalities are run, are elected, are governed, all in the run-up to next year's local government elections. So we thought it would be prudent to get a group of people together to discuss these changes and maybe share some information about what they are, how they will affect local government, and also what the challenges and the questions and concerns are that arise in the wake of these suggestions. So I had a number of conversations with Lance Joel of SALGA and Khalil Mulaji of SALGA Western Cape, and we came up with the idea of putting together this panel discussion co-hosted by the Dullah Omar Institute and SALGA with the support of the Hans Seidel Foundation as our kind donor. And so here we are this morning. I think the turnout is great, 74 people, and I'm sure some people will still join us as we proceed. And I think our panel is more or less complete. So that's great. And let me then hand over to the moderator for this morning, Professor Nico Steytler, the research chair in multi-level government attached to Dullah Omar Institute, and also my co-author in local government law of South Africa. So he also knows a thing or two about municipal governance. So Nico, over to you, and then I'll come back later to make an input. Over to you, Nico.
Thank you very much, Jaap. I think this is for me a great new moment. We are not hosting a webinar on COVID. This is a new back to normal. It's business as usual. It's about the nitty-gritty of local government. It is how we going to run the councils, and I think it's really for me a big step. We are looking forward. Lawmaking processes are busy. We are looking at the ordinary, everyday life of councils, and so let us kick off. We have, as you will see from the program, Jaap will make initial input on how what the impact will be, or the changes that are suggested in two very important amendment bills, the one to the Systems Act and the other to the Structures Act. That would be followed by comments by first Councillor Thembisile Nkadimeng, who is at the moment the president of SALGA. We are very, very pleased to have you on the panel. She's also the executive mayor of the city of Polokwane, and then also have a large international footprint as being co-president of the United Cities and United Cities and Local Government, which is an international body representing most local governments across the world. Then very fortunate also to have the Honourable Ms. Faith Muthambi, who is the chair of the Assembly's Portfolio Committee on Cooperative Government and Traditional Affairs. And it is at this committee that great where the two bills have been debated, even as a few days ago, on the 23rd of October, there were still debates on the Systems Act. And then we have last person is Louis Scheepers, who is currently the acting municipal manager of Knysna municipality. Louis has been walking the local government walk for many years. He knows it in and out, from practice through academia, and so we're very fortunate to have you with us. So let us immediately start. Jaap, you will give the input, outline what the amendments intend to do, and then raise a couple of questions, and then we will ask for the inputs from our panelists. Jaap, over to you.
Thank you, Nico. I've shared my screen. I'm assuming it's visible. I'm going to proceed until somebody tells me that there's something missing, but there should be slides on your screen. And if not, just shout. So what I want to do with this short input is give a short introduction into some of the key aspects of the two bills. And of course, for those of you who have been engaging with them in detail in Parliament or around Parliament, this would be something you're already very familiar with, but just to get us all on the same page, a quick overview, and then also raise a few questions that I have in relation to how this will impact local government, and what are some of the bigger questions that we need to address and can perhaps discuss in the further conversation. So, as was earlier indicated, two new sets of laws: Municipal Structures Amendment Bill and a Municipal Systems Amendment Bill. Just talking about what they entail. The Municipal Structures Amendment Act first. So this one is also proceeded to furthest, is already being tabled in the NCOP and has traveled through the National Assembly. It's a collection of amendments that regularizes a lot of things that had already happened, that had been discussed in the courts, or that had been emerged as practice in local government. So there's a lot of regularization of existing practices and trends and wisdom as well, but also a large number of refinements to the electoral system, which obviously have been sponsored by the IEC and inserted in the Structures Amendment Act, very necessary amendments to the electoral system. Overall, I think when we talk about municipal governance, there's a bit of an emphasis in the Structures Amendment Act to try to deal with this thorny issue of the division of roles between the legislative and executive arms of the municipality, which is always a challenge in local government because, as many of you would know, there's no separation of powers necessarily. There's no separate constitutional body in local government that separates the legislature from the executive. It's much more intertwined. The council has executive authority, but most of the executive authority vests with the executive mayor or the executive committee. And how does that work in terms of dividing the two sets of responsibilities is something that local government has been having to deal with over the last 20 years. And I think some of the changes that we see coming through in this Structures Amendment Act tries to strengthen the division of roles between legislative and executive functions in the municipality. So some key changes, and you know, my colleagues, particularly the lawyers amongst you, forgive me for the very short and probably a bit sort of crude summary, but you know, in the interest of keeping it short and focusing on the discussion, just very quick run through of some of the key changes, and there are many more because it's quite a large collection of amendments. But some of the key issues are, I think the following. The one is that the Act makes it possible for more councillors to be assigned, or more councillors to be elected in the most sparsely populated local municipalities. It's a correction there on the slide. It's not DMs, it's local municipalities. Because the challenge has been over the years that our most sparsely populated municipalities in the Northern Cape and some of the rural parts of other provinces, huge, vast areas with low population size, and then a very small number of councillors comes out of the automatic formula, which actually disadvantages communities in those sparsely populated areas. And this act makes it possible for more councillors to be elected to the most sparsely populated municipalities, with some rules attached to it on how those are calculated and who decides on the deviation from the formula that normally would apply. Then secondly, what the Act does, it sort of introduces formally now the Municipal Public Accounts Committees. They are not new. They, of course, always, well, not always, but they've been there for many, many years, promoted by the national and provincial governments and established by municipalities. And all municipalities have impacts and have integrated them into their municipal governance arrangement. But this is not a formalization and the regularization of impacts. Their membership is clarified, their functions is clarified, and also the flow of reports is clarified. And for example, to bring back that issue of separation of powers, impacts are oversight committees. They're not committees that are supposed to assist the executive necessarily. That's not their function. They're supposed to oversee the executive. So what the Act, for example, says is that mayors and members of mayoral committees, office bearers are not allowed to be members of impact, in an effort to try and separate the legislative oversight functions from the executive functions. So the impacts are now regularized in the Municipal Structures Amendment Act. What it also does is it regularizes the appointment of a whip, which was never really officially acknowledged in the legislation as an office bearer. There was only the provision in the legislation that allowed whips to be remunerated full-time. That was the only acknowledgement of the existence of whips. But their functions were not clarified, were not defined in any legislation, but they existed in many municipalities. I think almost all municipalities would have a whip or a chief whip of some sorts. And this is then the regularization of that practice, of that convention, if you want to call it that, into a set of provisions that defines what is the role of the whip in council. Then further provisions to clarify the function of the speaker. And in very broad strokes, it says the speaker is responsible for the functioning of the legislative arm of the council. It must ensure oversight. The speaker must ensure that oversight functions, that the committee structures function, and is responsible for the ethics and public participation. Those are the four key functions that are added to the list of functions of the speaker that are already in the legislation. So again, an effort to clarify this sort of legislative part of the municipality and separating it from what the role is of the more executive office bearers, such as the mayor and the members of the mayoral committee and the executive committee. Then ward committees are now compulsory. Of course, again, they were always there. They were always, from the inception of the local government system, ward committees have been regulated, but it was not quite made compulsory. Now it's made compulsory, and even a time period is attached to it that every municipality must have ward committees in place within a particular period of time. The Code of Conduct is moved from the Municipal Systems Act to the Municipal Structures Act. Quite interestingly, right at the beginning of the local government system, the Code of Conduct was part of the Structures Act. So it went from the Structures Act to the Systems Act and is now back to the Structures Act with not many changes made to it. I think it's largely kept as is, but simply moves from the one act to the other. Except for one change, quite an interesting one, is that in the past, it was quite possible for someone to be dismissed as a councillor in terms of the Code of Conduct by the MEC for local government, but then come back as a councillor almost immediately after that. I remember one story that was told that a member of a very small political party misbehaved, was sanctioned in terms of the Code of Conduct, was dismissed by the provincial MEC. It was a very small party, and that small party immediately proceeded to nominate the exact same councillor back into the council. So he returned almost immediately, and this was possible under the system. And this provision now makes it impossible, because there's a cooling off period, because you cannot be coming back to the council, I think, within 2 years after having been dismissed in terms of the code of conduct. Then another point that the Structures Act changes is that the MEC can designate a chairperson, a temporary chairperson of the council, when the speaker refuses to convene a meeting, which those practitioners amongst us, those who have been involved in local government, know this is often a problem when there is political upheaval, when there is political problems in a council. It can very often result in a speaker refusing to convene a meeting for all kinds of reasons. And then there can be a stalemate where actually the council does not meet. This then provision provides that the provincial MEC can in that instance intervene, as it were, and designate a chair that will chair the meeting when the speaker refuses to convene a meeting. Last two changes would be, the questions that I want to raise here is around the issue of impacts. We all know what, I think those who work in local government know impacts. They, as I said, they have been part and parcel of the local government system for a very long time. Yet the audit result outcomes keep turning out to be wanting and quite miserable, in fact, in many respects. So have they made a difference? And what will it take for these impacts to really make a difference in the quality of municipal governance and the management of municipal finances? One question, for example, is, will municipalities support impacts? I'm reminded of a conversation I had with a municipal manager quite a number of years ago, admittedly, when their impact complained to me that they were not allowed to meet, and that they didn't have any venue to meet, and that they were essentially meeting in the parking lot because the municipal manager was very uncooperative in making things happen for the impact and giving them a space to meet and administrative support and documentation. And when I challenged the MM on this, he told me right to my face that, well, why would I support an impimpi in my own organization? And that made me think that it's quite a challenge for municipalities to come to terms with the fact that there's an element in your organization that is there to oversee you, and you have to support this organization or this committee to make it work. On the code of conduct for councillors, again, a question I want to ask is, how do we arrest the weaponization of this code? It is there, and on the whole, it makes sense. It's not a brilliant piece of legislation because some of the areas are a bit confusing, but in general, it's a good code of conduct with the do's and don'ts of councillors. But practitioners will often tell me that, you know, the code of conduct gets holed out when it's convenient and gets ignored when it's convenient. It gets weaponized when we need to deal with a councillor that is on the wrong side of politics, and we do hush-hush with the code of conduct when it suits us. So is this the best way to deal with councillor ethics, this code of conduct, which in the end relies on municipal speakers and MECs and the council, all of them politicians, you know, to actually enforce it. And this has been a challenge, I think, that we have been seeing. Last question here on the MEC to designate a chair when the speaker refuses to convene. I haven't read the judgment of the Supreme Court of Appeal in the Tshwane matter yet, but one thing that it certainly does is it confirms the principle that the High Court set, is that walkouts are not allowed. We have this practice in local government where if there's, again, political upheaval and there's vehement disagreement on proceedings in the council, that a whole battery of councillors can walk out and collapse the meeting. and often are very convinced that this is the right thing to do, and this is a demonstration of commitment to procedure or to democracy. The courts have now said very firmly, you're not allowed to walk out. You get paid to be a councillor and to attend meetings, and walking out and refusing to attend meetings is not permitted. And I think this provision here is part of that trend, and it remains to be seen how this will be further enforced. Two further changes that the Structures Amendment Act makes is to the composition of executive committees. It only applies to municipalities that have executive committees. In other words, not an executive mayor, but an executive committee. The composition of this committee generally reflects the composition of the council. In other words, there's both ruling party as well as opposition members on the executive committee. And this Structures Act will now have a uniform formula that determines how the executive committee is structured. There was in the past a bit of a loophole where you didn't necessarily have to have an executive committee that completely mirrors the composition of the council. This makes it clear that more or less what the composition is of your council will be the composition of your executive committee through a uniform formula. And then lastly, tightening the rules on the declaration of vacancies. The Structures Amendment Act contains a number of provisions firming up the rules on the declaration of vacancies. Two questions there. The one is whether the composition of executive committees, this new rule, whether this will affect coalitions. What if the coalition wants its partners on the ExCo and it has to allow partners on the ExCo or parties on the ExCo that are not part of the coalition? Is something that I don't think we can discuss in detail in this meeting, but it's something to keep in the back of our minds as we go into elections, and we don't know what the outcomes, of course, are going to be, and whether we're going to have more coalition or fewer coalitions, and what this change will mean for those councils that do not have a full majority elected, and that have to contend with coalition negotiations. How will this rule on the composition affect that? Lastly, on the rules on declaration of vacancies, I think this is, in my view, an area where the Structures Amendment Act misses an opportunity, at least in my view, is an opportunity to deal with this question of why do we force accounting officers to adjudicate intra-party disputes? Because what the law says is that the municipal manager must inform the ISC that there's a vacancy. And it's stated there as if a vacancy is something that's very easily assessed. And it's something, just an objective reality that you can simply pass on to the IEC that, well, listen, by the way, there is a vacancy. Those of you who have been working in local government know that very often it's very difficult to assess whether or not there is a vacancy, because it often depends on internal party disputes and interpretations of party rules on whether or not a councillor is still a councillor. Because a councillor falls out with his or her party, there is an internal dispute, there is some sort of disciplinary, and at some point that councillor is removed from his or her party. But at what point does that become a reality? At what point is the councillor no longer a member of his or her party? It's not easily determined, and there's lots of very nasty disputes that we've seen on that issue. There are lots of court judgments dealing with this, and the rules are not always clear. That's fine, that happens in law, but what we're doing here is we're asking municipal managers to make that call. And I try to sort of make the comparison. It's not entirely fair, but it's a bit like saying that the Director General in the President's office gets asked whether or not the President is still a member of the ANC or not, because he has fallen out with his party. We would never accept that kind of arrangement, that the accounting officer, the senior administrator, would have to get involved in internal party disputes. So I'm thinking that this is something where the Act misses an opportunity. Why do we not ask the IEC to make that call, as that is an independent institution, well-versed and well-suited to make those kinds of calls, instead of asking the accounting officer to do so. Right, let me move on to the second piece of legislation, which is the Municipal Systems Amendment Act. And again, I'll do the same thing, a few remarks on what it says, and then a few questions by me on some of the concerns and difficulties that are there. Now, of course, I think as most of you would know, the Municipal Systems Amendment Act, most of the amendments are not new. They were passed in 2011. The Municipal Systems Amendment Act was passed in 2011 and put into operation. It was then subsequently struck down by the Constitutional Court in Samwu judgment because the Constitutional Court determined that the Act was not passed in accordance to the correct parliamentary procedure or legislative procedure. So it was struck down. Government was given 2 years to pass a new Act. Those 2 years have come and gone. So the Act technically has disappeared. You know, the 2011 Amendment Act, the amendment to the systems, has disappeared, but the regulations continued to be applied. There is then now the Municipal Systems Amendment Bill in Parliament that essentially reinstates these 2011 amendments and now, of course, following the correct legislative procedure. The key amendments that the 2011 Amendment Act suggests, on the left side of the table, all of those were there in the 2011 Act. So it's basically reinstating those issues that were already part of the 2011 Amendment Act and are now reinstated. So it regulates the recruitment process of senior managers and sets out a broad procedure on how municipalities must recruit senior managers. It sets the scene for the prescription of minimum competencies and experience and skills for senior managers, which are then put in the regulations under the Municipal Systems Act. And it also introduces a ban on political office for senior managers. So if you are a senior manager, you're not permitted to hold any office in any political party. You may not be an office bearer, a secretary, a treasurer of a political party. That is not permitted under the Systems Amendment Act, but it applies to senior managers only. This was, by the way, the main reason why Samwu took the matter to court, but it was then not, the merits of that issue were not dealt with in the Constitutional Court judgment because the Act was essentially thrown out on the procedural issues. The third issue that the Systems Amendment Act raises is that when a municipality makes a senior manager appointment, it must inform the MEC for local government that an appointment has been made and hand over all the documentation that went into that appointment so that the MEC can assess whether the appointment was done properly or not, and as part of his or her monitoring responsibility. The fourth issue is a moratorium on re-employment after dismissal for misconduct. So if any staff member has been dismissed for financial misconduct or other type of misconduct, there are rules in this Municipal Systems Amendment Act that that person may not be re-employed for a particular period of time. There's some rules on how a staff establishment is put together, and also a rule on how the minister, the national minister, may leapfrog the province if the province fails to initiate a Section 106 investigation in allegations of corruption and maladministration. That's primarily the task of the province to do that. And if a province fails, then the minister may leapfrog. Those are some of the key issues, again, very broadly summarized, that are in the 2011 Amendment Act, which is reinstated with the current Municipal Systems Amendment Bill. However, there are three new changes that are proposed as part of the deliberations of the Portfolio Committee, and they are quite interesting. The one is on the recruitment of senior managers. What the latest sort of suggested amendments to this set of rules state is that all Section 56 managers, in other words, all the managers that report to a municipal manager, the second layer, as it were, in a municipal administration, should all be made permanent. Those appointments, future appointments, must be done on a permanent basis. In the past, there was a bit of confusion, a bit of discretion, sometimes confused as uncertainty, that some municipalities would appoint Section 56 managers on fixed-term contracts. Most, in fact, would do so, but some would have them on 10-year contracts, and some would have them on permanent contracts. So there was an uneven interpretation of how this ought to work, which could also be interpreted as discretion, that municipalities could make their own decisions in that respect. And now the latest change suggested is that all Section 56 managers must be made permanent, the future appointments. Then the issue of the ban on political office, controversial. The reason why some took the matter to court. Obviously, some who had a victory in the Constitutional Court, but now it seems to have been a Pyrrhic victory, as they call it, a victory that comes back to haunt them, because now the new version extends the political ban from the senior managers to all the staff members in the municipality. So all staff will in future be banned from holding any political office. So not just the senior managers and the municipal manager, but all staff in terms of the latest suggestion. Then another proposal that has been made in the deliberation of the Portfolio Committee is on this issue of if the MEC makes an appointment, or if the municipality makes an appointment, it must inform the MEC that appointment has been made so that the MEC can assess the legality of the appointment. But now there's an additional provision that says that if the MEC does not respond, that the appointment made by the municipality of a senior manager is deemed to be in compliance with the law. I would imagine that this deals with the scenario where a municipality wants to know what does the MEC think, what is the MEC's view, because we've made an appointment, but we're not hearing back from the MEC. Is our appointment legal, yes or no? A few quick remarks on that. The issue of the Section 56 managers being made permanent, this is a long-standing discussion in local government. Is that a good thing? Is that a bad thing? Two questions there, maybe for us to ponder on. The one is, why not let the accounting officer appoint his or her team? Because the rules are still the same, in the sense that the council appoints the MM, and the council also appoints the Section 56 managers that report to the MM. But in the end, the MM must make things happen with his or her team, but they are then not appointed by the MM, him or herself, but by the council. And this has been a contestation that many municipal managers have told me is something that they would like to see changed. And if I am appointed in this municipality to make things happen for the next 5 years, I would like to appoint my own team. Of course, I have input and I get consulted, but in the end, it's not my call, and politics sometimes comes in, and then I am sitting with a team that I didn't choose myself. That's the question. Secondly, the permanency, having all Section 56 managers permanent. I suppose it's a good thing for stability, that you reduce this coming and going and the disruptive effects of these fixed term contracts, particularly towards the end of that contract. So it would be good for stability, but it's bad, particularly bad if it's a poor appointment, and then because then that poor appointment will be there forever and a day. So how do we strike that balance between seeking stability in the administration, but also having being able to deal with poor appointments? And I'm sure there are views on that in the audience and in the panel. All staff are now banned from political office in terms of the latest provision. For me, that is a positive development. I think it addresses the destructive practice of staff sitting below the senior management, somehow finding a way to ruling over their seniors simply based on political rank. Because I am more senior in the political party, I can ignore your instructions as an MM, or I can ignore your instruction as a mayor even, because I happen to be more senior when it comes to our party meetings. I think that is very destructive. We've seen examples of that. It's one of the things that wrought havoc in the Northwest, for example, in local government there. So for me, this is a positive development, but I'm sure there are other views on that as well. The issue of the MEC's response, if he doesn't respond, he or she doesn't respond, that then the MM's appointment or the senior manager appointment is deemed to be in compliance. From a legal point of view, I have a bit of a problem with this because it reinforces, in my view, an incorrect notion that the MEC's approval is needed for an appointment of a senior manager by a municipality. We've always held the view that the role of the MEC is to monitor and not to approve. So the MEC monitors whether or not the appointment has been made according to the rules. And if there's a problem, the MEC can go to court and ask for an interdict or a declaratory to force the municipality to revisit that appointment. But I think over the years, this has morphed into a practice or a tradition or some sort of system whereby the municipality thinks that its appointment is not legal until the MEC has put a stamp on it. In my view, that's not the intention of the law and would also not be permitted by the Constitution, because it is the municipality that makes its appointments and not the MEC. But again, I know there are different views on this, so it would be good to tease those out. The very last point I want to make is a very broad one, is about the Systems Amendment Act. In essence, it is really about professionalizing senior management in local government. That's the intention of the Act, with the competency requirements, with the rules on recruitment, with the ban on political office, etc., etc. The rules are there for municipal councils to adhere to. These are rules set by the national government, and municipalities must adhere to them. What happens if they don't? The enforcement is allocated primarily to the MEC for local government, the provincial oversight exercised by the MEC for local government via the courts, because if an appointment goes wrong, the MEC cannot just instruct a municipality to revisit the appointment or to change the appointment or to discipline or to suspend. In the end, if the municipality is unwilling, the MEC has to go to court or seek an intervention in terms of 139. So the enforcement is allocated primarily to the MEC for local government, who must monitor and ultimately via the courts or Section 139 intervene. The question is, what have we learned since 2011? Because this system is not new. It has been in operation. We are reinstating it. What have we learned since 2011, and is this the best way to professionalize senior management? I'm particularly keen to hear from Dr. Scheepers on his views on this. A lot of debate has been going on about what should the role be of professional associations, for example. Can they play a greater role? An association of municipal managers, an association of senior managers, associations of chief financial officers, can they play a greater role in guarding the quality and the integrity of their members as part of the system, as opposed to relying only on the state and on the MEC and on government, as it were, to enforce quality and integrity of senior managers? Because we have seen, I think, since 2011 that hasn't necessarily worked very well. We still see a lot of problems in local government with appointments gone wrong and with governance and administrative problems. Is there a greater role for professional associations to come in, just like they do with lawyers and with doctors, that if you misbehave as a lawyer, you get struck from the role by your peers and not necessarily by the government? Same with a doctor. If you commit medical malpractice, there are institutions within the medical profession that will deal with you, and it doesn't necessarily rely on a politician to do so. Can we move towards that in our local government system? Do we have associations that can do that, and would that be a better system? So those are just some comments to get us started, some questions, and I'm looking forward to engaging with my co-panelists and the audience to hear what they think of these issues. Thank you very much. Chair. Over to you.
Thanks, Jaap. Can we just, can you just remove your, there we are. Thanks for setting the scene. It looks on the face of it that it's quite important changes, that it seeks to streamline and where hiccups in the past occurred, trying to deal with it. But and I think, you know, no changes are always perfect, and the questions that you raised, I think, should evoke some comments and views, and I look forward to that. But let's turn to our panelists now, who would give a view of how they see the changes and the importance of these amendments to the conduct of municipalities. And sorry to drag in the COVID crisis, our municipalities are going to have difficult times lying ahead. The financial position is going to be tough, and obviously the mechanics, the oiling of the wheels of governing well is then very, very important. So can we unmute Councillor Nkadimeng from the President of SALGA? Yeah, oh, there's SALGA. There's Muthambi, thank you very much for joining us and also leading the SALGA at this very difficult time. And we look forward to your comments.
Thank you very much, and let me appreciate the presentation made and great colleagues and stakeholders this morning. Jaap did touch on specific issues and that are critical. Unfortunately, they've been on the table for quite some time. And I think the delays in terms of discussions and following them up are what has deepened the crisis and the problems at the local government. I must also greet the fellow panel members. Possibly before I go to responding directly to the questions as raised by Jaap, it's firstly looking at what was said by the study of local government in 2009. And it correlated exactly what is still on the table today. In terms of firstly, key from some of the issues that they have raised was the interference of councillors, which is undue. It was found as early as 2009 that was sitting with that problem. It looked into another or second concerning issue, which was a detrimental impact on the excessive use of political interference, either by external party structures, but because it was even not dealt with at that time, it then became internalized, because sometimes these party political issues could be external, but with assessment currently, you realize that it has now even moved internal into structures, both politically in a form of councillors, but administratively in a form of employees. And it became more entrenched, and it affects municipal governance in a whole. Now you also have employees who are now occupying senior political positions, and they are employees, and the governance of the municipality becomes very difficult, and it's not easy to intervene in internal processes following the legislations and the law. But the structures as well, politically, the report found that they should be discouraged from intervening or meddling in internal council processes to ensure the stability of the governance at council level. And then it also touched on the qualification and the capacity development of staff, and setting at least minimum qualifications and competences to ensure that the staff is professionalized. In the subsequent year, there was then a local government turnout strategy in 2010, which was focusing mainly in trying to resolve the key issues which have been raised. And it suggested that if we are, for example, to professionalize and ensure that administration is professionalized, we need to ensure that there is a direct plan on how you deal with the inadequate human resource capital that was there at the time. You come up with competency test writing, you come up with the key areas that the competencies are supposed to address. You look into the leadership and governance challenges. Some have been, a movement has been done and they've been carried. I mean, today, if you want to deal with the section 56, 57 appointment, they are supposed to be writing a competency test. Maybe what we may also have to look into with regard to that competency test, who has the authority? Is it the council? Because the current setup, it's a bit mixed. Some municipalities appoint their own agencies to get the competency written by a potential candidate. In other provinces, for example, like the province where I come from in Limpopo, the Department of Cooperative Governance has a panel which they've appointed themselves to be forwarded to municipalities to write the competencies, and you receive the report. And there has been discrepancies where in such instances the department sanction its own and the municipality sanctions its own, and there's one candidate but the results are different. You know, the other one says we are not competent, the other one says we are competent. And if I guess mine says I'm competent, then what does the legislation say? It says 14 days after council I must inform the MEC and not necessarily seek concurrence. So such also bring some spheres, disparities in terms of exactly who is supposed to check. And if we're moving for professionalization, it's some of the areas that we need to clearly outline. Now, you can never professionalize, at least we've realized. And this is what the strategy had also intended to deal with. Unfortunately, it might have not taken off properly. If you talk about professionalization, our assumption is that it leads to stabilization. My experience practically is that it's not necessarily the case. You or some municipalities, particularly cities, metros, are able to attract because they have got better pay, they've got convenience and everything, contrary to small and rural municipalities. In most instances, they are able to attract, but they struggle with the retaining because of the instability and the structure in how municipalities function. It is not necessarily, of course, always the case. I'll make an example. We advertised in Polokwane, I mean, which is the economic hub of Limpopo, twice or thrice, Director Electrical Services. I think the highest we are able to attract in terms of numbers, I could go back and refresh. I think the first advert had 9 candidates. The second had 11 or something like that. And we were at the time running with quite a number of vacancies. But at most, if you have attracted 30 qualified to enrich your prioritization and setting up of candidates, you would have worked hard. Or your response rate would have been hard, you know, and good. So the experience now shows us if we don't deal with the professionalization of the sector, it's unable to attract even if the pay is good. And our focus has always been and only been that they don't respond because it's only in rural areas, but it shows that people are beginning not to have an interest in local government, that is professionals, that even if you headhunt them, council give you an authority, get a company for headhunting, they look into the sector and you speak to people and they say, hey, local government is too unstable. And I don't want to bring myself that stress. Now, we went to an extent of auditing at the local government at the time. What skill do we have in our municipalities and what skill are we short of? And how do we bring that skill? If you go back to the second current audit now, it shows more erosion than the first, meaning at the end of the 5 years, or as you lose this skill that you had hired at the time of the audit, you are unable to retain it, or you are unable to ensure that their contracts are renewed. So the movement from one municipality to another is very strong. And that could be the prerogative of councils preferring in the main not to renew contracts, but rather to start afresh. But if you check and CVs of professionals, he works for 3 years at Guruleni. When his contract is about to expire, he applies in the city of Johannesburg. He moves for another 3 years in the city of Johannesburg. Then he moves to somewhere else. So that's the type of rotation that happens, and countrywide with regard to municipalities. And it makes it difficult for the professionalization of the sector. Maybe let me not talk to everything. I'm not sure how much time do I have, but I'd wanted to talk to the issue of the reports which are received for oversight with regard to the types of councils that we have. For example, and you did not touch so much on it, Jaap, because of there's quite a host number of things. So I'm trying to pick on the issues that may also be important for us. The executive mayors, they are entitled to only receiving Section 80's report. And the Section 79 committees, we need to harmonize that area, because that's what affects mostly the MPECs and other reports, like your ethics committee, which is tasked to be dealing with the ethical conduct of a councillor in any council. Now, the problem is sanitization of this report in how they are structured and the system is structured now. If you want true oversight, it means you need to be able to have a system which allows some form of neutrality, and even if it's attached to the very same council. Let's take an example with the National Assembly. Usually SCOPA, which is a similarity of an MPEC in terms of duties and functions at the National Assembly, is mostly headed by a member of the opposition party. In the past 5th administration, I think it was Honorable Godi. In the 6th administration, it's headed by the IFP. I think it's Honorable Mkajwa or something like that. In councils, we usually do not have that distinction. You are forwarded by your party. Your party also still appoints a chairperson of MPEC. So supposedly I'm politically senior, of which in most instances the mayor may be in that council, in that region. It's difficult or she's supposed to have in order for oversight to happen. I think I'd wanted to end there. Of course, if there are still more issues, for example, on is there a relationship between the appointment of municipal staff in a full-time and a part-time base with regard to clean governance and better provision of services. We've actually done an in-depth study as SALGA to compare the two and see professionalization with full-time office bearers, a professionalization with 5-year or contract. What is the distinction in relation to clean audits, unqualified audit with some findings, adverse and whatever? It's a mixed bag. One does not mean the total translation of the other. But what seems to be common is that if there is stability in the institution, there are processes and system, governance seems to be very clear, and oversight is helpful in ensuring proper governance. Prof, let me stop here. If there is an opportunity again, I'll come in with some more factors. Thank you.
Thanks so much, Councillor. I think it was very refreshing to listen to the voice from a coalface. You mentioned very clearly that these legal changes can take place, but they cannot solve all the problems. Much depends on underlying political will, social conditions, how you deal with rural areas, the way that there's a rotational system of managers going around, and also for giving a view of SALGA. And I think SALGA obviously played a very important role in actually the drafting and the inputs that produce these two bills. Now the bill came to Parliament and it has been serving before the Portfolio Committee on Cooperative Governance and Traditional Affairs, and the chairperson, the Honourable Faith Muthambi, was presiding over it. And probably after being Minister in Communications, you back at where you started. You worked a lot in local government, and you're probably happy to again get your hands dirty on the very practical issues about how we govern our municipalities. So, Ms. Muthambi, comments from your side, and how the important changes that came about, which Professor Visser mentioned, came through the Portfolio Committee. Over to you.
Thank you, Prof, for the welcome. Greetings to the fellow panelists. And then I want to appreciate also the presentation made by Professor Visser. Yes, where I can start, because you asked us to talk to two issues. What will change, and will it make a difference? So as and when I speak, I'm going to also concentrate on the second question. But I felt, as a general note, you will all recall, as Professor Visser has said earlier, the National Assembly has passed the Municipal Structures Amendment Bill. You will all recall we went to election, and then it means then it lapsed on the 7th of May, 2019. At that time when it lapsed, it was before the Committee of the National Council of Provinces, that is the Select Committee, in accordance with the processes outlined in Section 76 of the Constitution. So I will be pleased to let you know that on the 29th of October 2019, past our election, ourselves as the NA, we concurred with the NCOP regarding the revival of the bill from the stage reached in the 5th Parliament before lapsing. So the processing of the bill, I must assure you, is still underway, and it's in the NCOP. But to outside observers, I've seen the author of the article in volume 14, issue 1 of the Institute of Local Governments Bulletin, it may indeed appear as if there's been no significant action on the bill since the national and provincial election on May 2019. However, from where we are seated, I need to assure you, colleagues, that the intensive consultation processes which the NCOP has been undertaking with provincial legislature are far from being insignificant. As far as the object of the Structures Amendment Bill are concerned, I think Professor Visser has dealt much with it, but it's worth highlighting in response to the provocative questions posed in the subtitle of the invitation to this webinar in respect of the utility of these amendments. With regard to the first one that pertains to the repealing of all provisions dealing with plenary type of municipalities in order to abolish the plenary executive system, that's the first one. And the second one is to highlight it's in respect of clause 8, which provides for the cooling period, as Professor Visser has said. And then the last one, it relates to the municipal imperative to establish municipal public accounts committees as contemplated in clause 23 of the bill. To start with the last point, colleagues, and central to the oversight work of this portfolio committee over municipalities, we had always emphasized on the functionalities of MPACs. As the president of SALGA has said, if MPACs fulfill their oversight role effectively, it will ease the oversight burden of the two parliamentary cooperative committees and their counterparts in the provincial legislature. Time and again, as we crisscross the country, we find that MPACs are there, but are not doing what they are supposed to do. In many cases, this arises from insufficient appreciation of the significance of the MPAC as an oversight structure in the municipality. And then the issues, as the executive mayor has said, the president of SALGA has said, there's a lackadaisical attitude towards the MPAC, which then manifests in various ways, ranging from non-implementation of its recommendation by councils. Normally what they raise with us also is the issue of poor resourcing in terms of personnel, up to complete failure to establish an MPAC due to political dysfunction. Also, by insisting on an MPAC as a statutory requirement and codifying its function, then the structures bill, I think, will go a long way towards strengthening governance in the municipality. With respect to the abolishment of the plenary system, we have encountered anomalies where the function of the mayor and the speaker vests in one person. And we've seen it recently during our oversight in Mpofana municipality in KZN. And then the municipality, under the circumstances, is then unable to delegate its executive responsibility because it does not have the minimum number of councillors required to enable it to establish an executive committee. Therefore, the establishment of the plenary executive system, coupled with the requirement for a minimum number of 10 councillors in the municipality, should therefore then assist to address these anomalies. With regard to the 2-year cooling off period for councillors found to be in breach of the code of conduct, the point is that ourselves as a portfolio committee, we have encountered many cases of municipal dysfunction that warrant intervention in terms of section 139(1)(c) of the Constitution. Then what we have encountered and experienced is the major problem with this type of intervention is that after 90 days, the same councillors responsible for the dissolution of the council return to office and to continue to destabilize council as before. The recent cases, you can look at your Malutu Apofongo municipality in the Free State and also your Mamusa local municipality in the Northwest. So this defeats the objective thereof of section 139(1)(c) intervention. So the 2-year cooling off period should assist tremendously, provided that the MECs then they act decisively and speedily in terms of investigating and removing councillors in breach of the Code of Conduct. Coming to the Local Municipal Systems Bill, Amendment Bill. At the Portfolio Committee level, I should assure you colleagues, we have almost concluded processing the bill and will be soon be submitting it into the National Assembly for second reading. As Professor Visser has said on this matter, you may all be aware that the most provision in this bill relates to the prohibition of senior managers from holding political office. In the latest version of the bill, we have also now extended this provision to all staff in the employee of the municipality, on the realization that even relatively junior staff members can wield powerful political interference into administrative affairs of the municipality. We are mindful of the fact that it's not going to be a popular amendment, and we are anticipating resistance. Talking to this issue of junior official wielding powerful political interference, a week ago we visited Mfulweni local municipality in Gauteng. There's an official who's said to be a regional secretary of a political party, who happens to be then a supply chain officer. So that power, you could see him wielding it the way he does it in terms of the issue who gets the tenders. So I know this is a matter that we're going to experience resistance, but it's the matter that we're going to continue fighting, because we've also sought legal opinions. There's nothing that prohibits us from doing such. However, after exercising all the necessary due diligence, all the political parties represented in the Portfolio Committee have unanimously agreed that these amendments are necessary to the professionalization of the local government, and that it is in the best interest of the communities we are elected to represent. One is of the view that the passing of this bill will also enable us to claw back the gains lost following the invalidation of the amendments introduced in 2011 by the Constitutional Court Order of 8 March 2019. Just recently, we encountered an MEC who refused to intervene in questionable municipal staff appointments due to the invalidation of this provision that authorized him to do so. To be unable to bring an MEC to account for questionable appointments in a municipality, I think is highly incapacitating and makes mockery of our oversight rule as a committee. We are therefore of the view that this is very important to pass this bill to then remedy this. The issue of skills and qualification is very important, such that we are also extending the requirement to have the requisite skills, competencies, and qualification, even to acting Section 56 managers. This should inculcate a culture of hiring qualified personnel regardless of the nature of their appointments. So it's gonna apply across the board. The other issue that one wanted to raise was with regard to the final amendment of note, which is in respect of affording the municipal council discretion to appoint Section 56 managers on a fixed term or on a permanent basis in consultation with the mayor or executive committee, following a recommendation by the municipal manager. This has been the practice all along, and we are maintaining the status quo because the evidence presented to the committee is not conclusive as to whether fixed appointments are advantageous over permanent appointments, or vice versa. In the bill, we are merely then making the status quo more explicit, with emphasis on the discretion of the municipal council as to guard against the misunderstanding and misuse of powers at some time by municipal managers in respect of the managers directly accountable to them. I then want to then deal with these issues as I'm trying to conclude these matters, which I think is a matter that we must all then look at and consider. If you read Section 154 of the Constitution, It states that national government and provincial governments, by legislative and other measures, must support and strengthen the capacity of municipalities to manage their own affairs, to exercise their powers, and to perform their function. To us now who are here in this platform, what does this mean? Support and strengthen by legislative measure, it means that laws in the form of acts, amendments to acts and regulations must be put in place when weaknesses, shortcomings, abnormalities, or failings have been recognized or are encountered in order to overcome this. There are a number of ways that such acts and amendments to acts may be initiated. We all know that regulations in the main are as a result of powers accorded to ministers, premiers, and MECs by various acts. We're not going to get into the nuts and bolts of this. Then the issue that is very critical for our discussion is this: how do municipalities exercise their powers as anticipated in Section 154? They do so through council, committees, and office bearers created by the Municipal Structures Act. So the conclusion that we can draw from this, what I'm saying is that, yes, there are weaknesses, shortcomings, abnormalities, and all failings in the structure of council, committees, or office bearer. And then this Structures Act is then going to remedy this. Similarly, one may ask the question, then how do municipalities then manage their staff? Once again, as anticipated in Section 154. Here they do so through a staff establishment created in the Systems Act. Once again, any weaknesses, shortcomings, abnormalities, or failings with regard to the staff establishment, this can be rectified through the amendment of the Systems Act. So the issue that, as I'm concluding, is to say, let's now say, what difference will it make? Our considered opinion as a committee is that with regard to any law, its success lies on how it is interpreted or translated to execution purposes, if at all. Many of the failures at municipalities are not as a result of inadequate, progressive, and developmental laws being in place, but they are as a result of poor capacity or lack of political will to implement. I'll quote, as I'm closing, the example of Section 87 of the Municipal Systems Act, which enables 2 or more municipalities to form a multi-jurisdictional municipal service district for the provision of municipal service. In terms of Section 88, the Minister of Culture may even request 2 or more municipalities to form a multi-jurisdictional municipal service district. To date, where I'm seated, a prof, I'm not aware of such a multi-jurisdictional municipal service district. Maybe one of you experienced and learned colleagues are aware of one and may bring it to my attention. Maybe it will also manifest in the district development model, but the System Act is with us for 20 years, and this could have been service delivery solution in many areas of our country between municipalities. I should stop here, and as I'm concluding, I'll say, will it make a difference? With proper implementation, it will definitely make that difference. Thank you so much, Prof.
Thank you very much, Ms. Muthambi. I think you said it out very clearly why these changes came, and that the policy choices that underlies them were very well set out. And it's also heartening to know that there are full agreement across the political parties about the need for professionalization of municipalities, and that that professionalization is going to be critical for municipalities to provide the services that the communities require. But I think also, very importantly, your last point is you can make laws on the national level, but it's the implementation by municipalities themselves, that they have the buy-in. And we got that from the president of SALGA, that this is very much a collective effort. So thank you very much for that input, and I'm sure there will be questions. There's already the chat box, a very lively discussion already going on. We encourage you for further comments and particular questions if you want to pose, and we'll direct them to the panelist. Now, Louis Scheepers, you've been waiting there. There's great welcome on the panel, and you are also at the coalface, knowing precisely what it is to be a manager, and we all look forward to your input on what changes what impact these changes will have on the lives of municipal managers and senior managers. We look forward to listening to you.
Thank you very much, Professor Steytler. Good morning, everybody. Good morning to my fellow panelists and everybody in the webinar. Will you allow me to make use of this quintessential South Africanism by saying all protocols observed, so that I don't get into trouble if I don't use the right, if I don't recognize the correct people. I must say to you that I'm like a kid in a candy store, because there's such a lot that one wants to speak about. But I think I'd have to probably narrow my discussion to only a few of the points. Let me also just thank Professor De Visser and Honorable Executive Mayor Nkadimeng and Honorable Muthambi for their inputs. It's really been enlightening, and I've really enjoyed listening to it. I think when we talk about these things, I think we need to do it within a particular context. And I want to just say, you know, recently a former speaker of mine, when I was at the Saldanha Bay Municipality, Alderman Ibrahim Nakadin, passed away. And when he passed away, I thought about something very profound that he said one day. You know, we often say that local government is the sphere of government closest to the people. And one day, Alderman Nakadin, the late Alderman Nakadin now, said to me, but you know what? Local government is not only the sphere of government where government is the closest to the people, but it's also the sphere where the people are closest to government. So, you know, talking about local government, being involved in local government is very important, because local government is probably the sphere of government that impacts on people's lives the most. I want to just set the scene before I talk, you know, go into the detail of what has been presented to us before. And the first thing that I want to say is something that I think as South Africans we need to probably still learn, but is to say that complex challenges for me require simple solutions. You know, sometimes we complicate the solutions that we want to bring to the challenges that we face. And in that way, we're not dealing with the challenges, but we're probably adding to the challenges. So complex challenges require simple solutions, I think. I think also we often talk about capacity, and for me, capacity is in equal measure two things. It is on the first part, the ability to do something, but it's secondly also the will to do something. So you can have all the ability to do something. If you don't have the will to do it, you don't have capacity. And I think that's important that we take that into consideration. Criticism that I've often had on what we do in local government, but in government in general in South Africa, is that we often come with knee-jerk reactions to the challenges that we face. So we're faced with a particular problem, and then we want to deal with that specific problem, and we come with policy and legislation, and it's very often knee-jerk, and it doesn't lead to sustainability and looking at things in the longer term. So what I want to say in what has been presented to us this morning by Jaap, I think the elements of, you know, really looking at long-term sustainable solutions, but there are also elements where I think there's a bit of knee-jerk reaction going on. Local government faces a lot of challenges, and a lot of authors, a lot of people have spoken and written about this, but there are a few that I want to highlight. So one of the challenges is that we have a very complex legislative environment. Two of the panelists have previously spoken about the strangulation of local government through the legislation that we have. So that is something that I think going forward we need to work on. How do we simplify the legislation that local government has to deal with and that regulates what local government does? And then the one thing that I'm very happy to see that the Structures Act now look at is this whole thing about, you know, the not clear separation between the legislative and the executive authority in municipalities. And I'm very happy that the Structures Act now attempts to get to that. I also think that the demarcation of municipalities and this whole notion that bigger is better is always better, that bigger is always better, is something that we need to do a whole lot more research on, talk a lot about, because I think there are some municipalities that simply because of their geographic size renders them almost not able to be viable and sustainable in the long term. I think the fiscal and financial capacity of most municipalities, being revenue-raising institutions, is important. We need to continuously talk about that and look at that. And then the skills and capacity of local government, political and administrative leadership that has been raised by some of us here today is also important. But the missing point that I find in that discussion is we often talk about local government capacity, but we don't often talk about the capacity of provincial and national government to fulfill their oversight and their monitoring and support functions. And I think when we talk about local government capacity, when we talk about the system of local government, it's important that we also look at the capacity of the provincial and the national government to perform their functions in respect of local government. So to pull that all together, I think we need to have a look at local government at the macro level. In other words, the overall system of local government, the laws that govern it, the fiscal relations and so on. We need to look at it at the meso level. In other words, at the individual level of municipalities. And then we also need to look at it at the micro level, you know, looking at the individuals involved in local government. And we talk about capacity, we must talk about capacity in those three levels of local government. I am going to focus, also being mindful of the time, much of what I want to say on the whole question of professionalization of local government, because I think that is the big challenge that we're still facing. I see a lot of colleagues on the webinar today. I see a lot of people that have been in local government for many years. And I also see a few young, fresh-faced people, you know. And I think I've often heard in the last while, and this worries me tremendously, local government practitioners saying, listen, I don't find it fulfilling and I'm not happy in my job anymore. And when you scratch beneath the surface about what is this about, you find that a lot of the things that are now being attempted in the amendment of the Systems Act specifically are the things that come to the fore. There are a few things that I think we need to take into consideration. I think as officials in local government, we need to understand that we work in an environment of political supremacy. What does that mean? It means that the people that hold the democratic mandate are the elected representatives. We must accept that. You cannot work in local government or in government if you don't accept that. But at the same time, I think what we also must understand is that even though elected representatives, you know, carry the democratic mandate, we must not create a system where those political representatives, those elected representatives, have the ability to exert undue influence on officials, especially in local government. And that unfortunately happens to a large degree. Now, what you see in terms of the question about permanency or not of Section 56 managers, and I'm hoping that at some point we'll talk about municipal managers as well, is that because of the short-term nature of contracts as most municipalities do at the moment, local government officials, senior officials in local government are often delivered to undue political influence exerted by elected representatives. Because every 5 years or so, you know, officials have to look into the eyes of the political leadership and get a new contract. Now, the impact of this on what happens in municipalities is that there's a lot of short-termism. So people are concerned about what is happening in the short term, and we lose a lot of the long-term focus that municipalities must have. Because the reality is that the decisions that municipalities, that both political leadership and administrative leadership make in municipalities have long-term impacts on communities and on municipalities as institutions. So I'm thinking that what we have at the moment, you know, that the Systems Amendment Act is partially addressing is this whole question about forcing senior managers to be mindful of the fact that they have to look for a new contract in a short space of time. 5 years is a very short space of time, and it has an impact. The question of professionalization and professionalism in local government, for me, it's been a topic that I've been very interested in. I've written about it before, and I think it's something that the Institute of Local Government Management, that I'm a member of, has been taken up very, very strongly again in the recent past. And it's something that I think will provide some of the answers. It's not the panacea to all the problems that we have, but it will provide some of the answers to what we're facing in local government. We need to have a situation where there is an element of self-regulation of the profession of local government management, like we have, as Jaap has indicated, like we have in other professions, like we have in the engineering, in the legal, in the medical and other professions. We need, as professionals in local government, to take responsibility for the professional conduct, or sometimes lack of conduct, of those that share the profession with us. And they are, I mean, this is not something that requires innovation. There are models that are available that we can implement, but I think it's important that we take responsibility for this. Now, the question that comes up is this question of you know, if you make the wrong appointments and they are permanent appointments, what do you do? And it's in the professionalization of the occupation of local government management that I think you find the answer to that. If the profession is structured in a way that there's self-regulation, and it's structured in a way where those of us that are involved in the profession says that if wrongdoing is allowed to continue, it not only affects the person that is responsible for that wrongdoing, but it affects me because, you know, because I share the profession with that person, I will also be viewed in that light. I think that will force us to a certain degree to look at that. Local government is a little bit different than the other professions because we work in the political environment. So it's easy for lawyers to say, you know, we will self-regulate ourselves. It's a little bit more complex for local government officials to do it. But I think by having hybrid systems in place where we not only look at where we couple the oversight of the state actors with the oversight of the professional organizations, I think that will lead to a situation that will assist us greatly in that respect. So I think in that whole question of professionalization, the question of certification. So in other words, you need to be certified by a recognized body in order to practice in the profession. I think that's important, and we should be moving in that respect. There's a lot that one can say about this situation, but I think I want to just end off by saying, and I've been saying this to a lot of people in the recent past, you know, local government officials, senior managers in local government, not only have responsibilities, we these days also have liabilities, both criminal and civil liabilities, because the legislation says that we can be held criminally and civilly liable for the actions that we perform and the things that we do as local government officials. So we need to be mindful of that fact, and we need to ensure that we insulate those that have the responsibilities that open them up to these criminal and civil liabilities, that we insulate them from undue influence, whether it's political or community or whatever influence it is, business influences and so forth. So we need to provide that insulation for them against that. And I think we'll go a long way if we do that. So overall, I want to say that the amendments that are proposed for me, in a general sense, are very positive. I think it moves us ahead. I think, Honorable Muthambi, there'll probably be a big fight about whether it's constitutional to bar people from holding political office. I'm actually looking forward to that. Some of us actually get a kick out of these debates and discussions. I'm looking forward to hear what the arguments for and against that will be. But ultimately, we need to ensure that we have a system of local government that is strong, that is resilient, that is able to address the big challenges that we face, that can provide to our communities what the Constitution says that we must do. And that is to provide them with democratic government on the one hand, provide them with services in an efficient, effective, and sustainable manner, and also provide for the development of our communities, so that we take them from you know, what is the history of years and decades and centuries of colonialism and oppression, and provide them the opportunities to prosper and be sustainable. I think we're struggling as a system of local government. We probably not performing at the level that we should be performing. And I'm hoping that what we see in the amendments going forward will help to unlock the potential of local government and make it much more easier for us to perform the functions and do what we're supposed to do. Nico, I'm going to stop there for now. I can go on forever. Those that know me know that these things are very important to me. I like talking about them, but I think to allow for other interactions, let me stop there for now. Thank you very much.
Thanks very much, Dr. Scheepers. Clearly, it's a passion for you, and many of us, local government is just simply not just an interest, it's a passion. And it shows really that we engage with local government as citizens, and as you say, it is the government closest to the people, but people also, this is the government at first hand. Thank you for your views. What I propose now is that there's a couple of questions raised and general themes raised in the chat box. I would list them and then ask that we go through the panelists and to see how they comment on these various ones. We haven't had direct questions to particular panelists, so each one can respond to it in their good time. I said this is not about COVID, this seminar, but I think it is. Because what lies ahead, we're living in this new post-COVID world, is that municipalities almost has got more to do in terms of services, in terms of rejuvenating or getting the economy back, and they will do so with less money. And so these changes, amendments must be seen in that light. 4 main themes came through in the questions and comments. The one is clearly is the professionalization of local government. The second one is how do you achieve clean government, and this is something that have many reports on that. The third one is a stable local government. The instability, the political instability, we will have to look at seriously. And then the fourth one is an effective local government, which links closely to professionalization. So let me just put 1 or 2 questions there, and then we'll go back to our panelists. On the professionalization, it seems very clear that everyone is in agreement, separation of party from the state and the administration, and there haven't been any arguments against it. The one would be an interesting question, which I think should be addressed both by SALGA and chairperson of the Portfolio Committee, is this role of institutions? Is there a real good role to be played, and it is suggested by, I think, both by Jaap and Louis, about institutions also taking responsibility for the conduct of its members. The second one is, yes, you can professionalize. Can that professional body actually provide clean government? And here the question has been, impact, very important, is now compulsory, but how does it make that it can bite? The research that we've done found that in some municipalities which had terrible Auditor General reports, there were none. Will it work as is? Do you need further teeth? Do you institutionalize the old tradition that an opposition member actually chairs that committee? On stability, political stability, with the chief whip, provide new stability, because very often, if there's instability at the top, it permeates down to the bottom, and you have serious problems in your administration. And the last one is effective government. You can have a professional body, but how are they going to be effective? And that comes with the question of the appointment of, and the permanent appointment of, senior managers. And I think there the debate should be, do you have a team of each municipal manager, which then requires not the permanent appointment, but actually coincide with the term of the MM, or do we have a different model on it? So on those questions that came through, and there will be more, Jaap, shall we start with any reflections on your side on any of those questions?
Thanks, Nico. Let me give it a go, and thanks to my fellow panelists, really fascinating inputs, and I learned a lot this morning. So so thank you very much to all three. Let me just pick up on the issue of the neutrality of impacts and the teeth that they ought to have. And I think we must also see it in the context of sometimes the crude reality at local government level of these issues being about who gets the full-time position. And unfortunately, that sometimes plays such a major role in the background. And I remember having discussions with mayors about these issues, and their key concern is, how do I keep my alliances intact, both internally within the party and externally? How do I keep my alliances intact? And for that, I need to be able to allocate full-time positions to key people in this municipal council. So, the making an impact chaired by the opposition, I think would be the way to go if I can buy into that tradition. But the reality at local government level is often so centered around the full-time versus part-time position of councillors. And I think that's where sometimes these things get stuck. But I think we need to move towards that. We need to move towards a system whereby impacts are not seen as the impimpi, but are seen as a necessary element of good governance, and that it's much better to pick up anomalies and issues internally with the use of an impact, as opposed to letting it fester and allowing it to be picked up by the courts or by the public protector, or splashed out all over the news, and then the consequences are much worse. Nico, on the issue of professionalization, what I see sort of happening is that the national government seems willing to engage with the issue of self-regulation, but seems to argue that let us continue with this system as we have it now, where the focus is on the state to enforce integrity and quality. And then over time, if and when we're ready, we're going to maybe go into a more hybrid model that Louis was referring to, bringing in the associations to help with the self-regulation. And maybe that's the way to go, because we are building an edifice of professionalization through these regulations, edifice of a political ban, the edifice of rules for recruitment, of minimum competencies, etc., etc. And can that lead to a greater role for professional associations? The question, of course, is will the state hand over that power? Self-regulation means the state will have to give in and will have to hand over some of those authorities to those associations. And I'm looking at how provinces particularly interact with municipalities, and I think that the tension was highlighted by Councillor Nkadimeng. I'm a bit cynical as to whether provinces will be willing to give up this oversight role completely. Last point, a very general point I want to make is a lot of these issues take place within the context of looking at of local government autonomy. National government must always hold back in the way it regulates local government. Don't go too far, don't interfere, allow discretion, respect local autonomy. Provinces can't go too far. Municipalities have a very well protected sphere of local autonomy that also extends to these issues of recruitment, selection, staffing issues. The broader question I think we need to start asking ourselves is we've now enjoyed that autonomy for 20 years. And what have we done with it? And this is the kind of questions that Louis is also asking. And because there is a level of, if I can use the Afrikaans word, gatfulness with the failures of local government. And at some point that is, I think, is going to translate into a willingness to reduce its autonomy and say, okay, you've been given this autonomy to appoint your own staff. You've been giving this autonomy to run your own affairs. You've sued us successfully when we go too far in interfering it. We are now ready to change the constitution and remove some of that autonomy. I don't think we're there yet at all. Nobody is raising this, nobody is saying this. But this is the kind of frustration that you start seeing in the system. Those that are exercising oversight and also the public. You can see it in communities suing provinces saying, why are you not intervening in this municipality? Why are you not reducing this municipality's autonomy? Because it's failing. So the issue of local government autonomy, which we always write about and we're very proud of, and we brag about it to our colleagues overseas and elsewhere on the continent, that autonomy, I think at some point is going to be at risk if we don't improve this system and heed, I think, Louis' call about taking responsibility for the functioning of local government. There are many more other things I would say, but let me stop there and allow the other panelists to also come in. Back to you, Nico.
Thanks, Jaap, and thanks for your unparliamentary language there. I'm sure the Honourable Muthambi would censor you for that, but I think that is the rub of the issue, and it's a critical one. You know, if in fact after 20 years we get intervention after intervention in the same municipalities, nothing changes. With that, let's go to Councillor Nkadimeng about how SALGA sees these challenges.
Well, thank you very much, Nico. I think I would like to start where Professor Visser has ended, with the the autonomy. I'm not sure, Jaap, whether we've had it. Yes, it's there in the structured in the legislation. But lo and behold, Professor Scheepers knows, Dr. Scheepers knows that at any appointment in any of the provinces, when you have to make a municipal manager or a Section 57 appointment, you still have to deal with the issue of the concurrence, which is not legislature, which means the autonomy, it's not there. It may not necessarily be 100%. But I'm going to make an example, secondly, where municipalities themselves write and request intervention with regard to Section 154 on a number of issues that they, in their own assessment as a municipality, they will realize we're lacking here, we're lacking there. Let's ask, and there will be no response, and there will be nothing forwarded. But we're also having instances where, irregardless of this autonomy, where performance is not necessarily the issue or could still be enhanced, but Section 139 will be preferred even when it will not bear results. So we may have to look into some of these issues and compare really what would have happened practically with regard to the test of that economy. I agree with the fact that professionalism will bring institutional integrity. And Dr. Scheepers has raised the issue as well. And you have raised the issue. And some in our chat box do say, for example, the reason why we're unable to attract it's because we prefer some form of appointments which are not helpful in the system, but more politically aligned in terms of keeping the political status quo within the municipalities, and that is not helpful. But the fact of the matter is, as the situation stands now, if we do not professionalize and push towards a body, as Dr. Scheepers says, that seeks to demand accountability from its own professionals and practitioners, we seem to be having a difficulty in attracting the very same skills. It's easy to lose trust. It will take a fundamental difference and a long time coming for us as a sphere to build the trust that has been correctly eroded from our communities, including professionals who now say, I don't think I want to work for you. The package looks interesting, but the underlying factors makes me not to think I could be able to even realize what are the aspirations of what the municipality would want to achieve. So this autonomy versus micromanagement, if also you do not have the body that will protect not only the professionalism, but also the laws and the functionalities of that profession. Let's take DINOSA, for example. It's clearly known what is the responsibility of an S. What are the requirements? What are the legalities that governs the profession? You cannot then make a nurse a doctor and vice versa. But the other one is a supporting structure to the doctor. They have got limitations. There's something they can't do without the authority of the other. But the sphere itself, the parameters are clearly set. And that is what will help us here to maintain what local government is about. Because if you have got a law, you have got a society that looks after it, you have got the ethical code, you have an improved MPEC in terms of its oversight, the cycle sort of does get completed. Of course, putting performance management, something which we have not spoken about because we couldn't, but is not absent in this loop of what will make municipalities functional, because you hire professionals. If you don't give them space, they can't perform. Some live in the spaces there, but they are not performing. And there's nobody who says they are not performing, and the municipality goes into it deep. Thank you.
Thank you very much, Councillor Nkadimeng. For that, yeah, not counter view, but was there autonomy? Is there abuse of autonomy? But the question is clearly very, very pertinent, and it may even become more important now that we see that councils would have less money, and the money that they will receive in transfer will be much closer observed. Could we go to the Honourable Muthambi now, just for her comments?
Thank you. I see there were questions meant for me on the chat group.
Yeah.
The other one was about the status of the bill. I've indicated that at the level of the committee, we have almost concluded the processing of the bill, the Municipal Systems Amendment Bill. And then before the House rises on the 30th of, in fact, if it's not week, if it's not next week, it's the following week, there's an item on the agenda of the NA that says we must be dealing with legislation. So this is the bill that we'll be submitting it to the National Assembly. Like I've indicated, we've concluded it. There's been consensus on all the matters. That was the first question that was directed to me. And then there was the issue that was raised that about the legacies attitude towards MPEC. I think the person who asked the question have misunderstood me. I didn't say Cocta has got an attitude. It's about councils. As Honorable Councillor Nkadimeng has also indicated to say there are a lot of factors. But on our side, because the question further says, what have we done as a committee to expedite the finalization of the bill? I was expecting that, as I've indicated earlier, to say with regard to the structures bill, what we did as the NA, because we've seen, you remember the Constitutional Court judgment, no. You remember this bill lapsed with the previous election, but we took it upon ourselves as the NA Committee of Parliament to talk to the NCOP because it lapsed while it was at the NCOP side. So we took it upon ourselves to talk to the NCOP so that we revive the bill. And as I've indicated, the bill is underway. There's the other House of Parliament that's dealing with this. It's being processed by the NCOP. I know the NCOP has been doing consultation throughout the provinces. So what I can tell the person who asked the question on this one, it's in our interest as the Portfolio Committee to make sure that this bill post the consultation processes must come back to Parliament so that then it can be finalized, then they get enacted and passed as law. So that's the matter that we're sitting on top of it because the situation then is so unbearable because I've indicated with you now, with the nullifying of the 2011 Amendment Act, I've told you that we've got difficulties that the MECs now cannot give concurrence on appointments as well, because that law doesn't exist anymore. So these are some of the issues that we feel, and it can't be that then we were interacting with another municipality where in council decided to appoint somebody who's not even qualified to do the work as an MM. And then when you look at that institution, there's complete disregard of laws and regulation because you look at the capacity of the staff that is there as well. And when you ask the MEC, he will tell you, I'm not empowered by any legislation because the 2011 amendments have fallen away with the Constitutional Court judgment. So that's why we feel we need to expedite this issue of the bill that it gets finalized. On our part, I think we've done what we could do within this short space of time. That's why we're saying we've prioritized this legislation with the support of SALGA, definitely. Though there was contestation on whether Section 56 managers should be permanent or whatever, until we reach a conclusion and consensus that should be in the discretion of the council. The same thing with the issue of the MM, because there's a question that raised to say, now, why are you only giving that provision not only for the MM also to be under same conditions? I'll give you a classical example. If you recall, for some of us, you, Prof, in particular, you recall with regard to Durban, eThekwini Metro. You remember that Dr. Michael Sutcliffe served, I think, if not 10 years, 15 years in that city, by which that council will still take decision to renew his contract. So there's nothing that bars a council to continually renew the contract of an MM if this MM is performing. Definitely it's performance based. So these are some of the matters that I felt I need to do. Also to comment on what Dr. Scheepers has said, and somebody has put it on the chat group here. The environment of local government on the professionalization part of it. It's one toxic environment, I will agree. Because at times, if you look, you peruse all these AG's report, there's a situation where you find that they just complete disregard of the laws and regulation. And you go there, as a professional, because I'm still to ask Dr. Scheepers, how did he choose to become an MM of Knysna, acting MM? Because if even today, no matter, Prof, you can give me 3 million or whatever the salary is so lucrative, I'll refuse to go and work in local government, knowing what happens there, because majority of people who are there, they don't want to comply with rules, laws, and regulation. And you go there, you want to apply laws and regulation, you'll be on the wrong side of them, and they will deal with you until you exit the system. So these are some of the things that with this law, we are trying to do that. The beauty about it again now, with the kicking in of the new Public Audit Act, there are municipalities now that the AG has started to issue letter of demands for somebody who has been responsible for the unauthorized, irregular, fruitless, and wasteful expenditure to start to pay from their pockets. I should think then if that provision of the Public Audit Act then gets enforced. Some people now, even if it's a political pressure, as an accounting officer, you'll be able to say, no. At the end of the day, it's me who's gonna pay the brunt here when I'm supposed to pay out of my pocket. So I should think, like, as I've emphasized earlier, Prof, to say the laws are there. The laws are there. It's all about the will of people to implement those laws. Because whatever the AG is finding, you see now on the decline, on the regression of the audit outcome, generally you look at that, it's just non-compliance with laws. You can see that people opt not to comply. So you need a situation wherein then, I think with the tool of the Public Audit Act, people will be scared now to say, if then I incur an authorized, regular, fruitless, and wasteful expenditure, if I'm to pay out my pocket, people are going to then think twice. Thank you so much.
Thank you very much, Honorable Muthambi. I liked your question, which I'm going to pose now to Louis Scheepers. There are 3 questions, Louis. The one is, why are you a municipal manager? Because absolutely correct. It is probably the toughest job imaginable. The amount of laws that you must comply with, and I can just show this is just a box full of laws that you have to comply with every day. And we have long been arguing about strangulation. The second one is a specific question that came about thinking a bit more about the role of professional institutions. Is it compatible with the lawyers, or lawyers with doctors, etc.? The notion of a professional association or institute for MMs. And then a question which was raised by Jaap, but not been addressed yet, is how would you think about the notion, being an MM now, that your team was not selected by you, you would arrive at a municipality supposed to do, appointed to turn it around, but the team is permanent. Right, a few tough questions.
Yeah, I was first appointed as a municipal manager in 2001. And at that point, it was the highlight of my career. I was so proud of being a municipal manager. And I must tell you, now I'm doing it purely because of a sense of duty. It has become tougher and tougher, and it's not only me saying so. I speak to a lot of my colleagues, and this is the general idea that comes through, right? So I often say these days, somebody that decides to become a municipal manager or a senior manager in local government, we must refer that person for immediate psychiatric evaluation, because there must be something wrong with that person. But it can be, I think, let me not be too negative. It can be, it should be a very fulfilling profession, because you have the ability to directly impact on the lives of people on a daily basis. You know, you deal with the delivery of services to people, you deal with the dignity of people, you have the ability to impact on that. So we need to get back to the point where we become proud of being municipal managers again, and where young people aspire to be municipal managers. It's a long road ahead of us. I think there's a lot of work that those of us that are still in the practice and the political leadership that must make the policy and the legislative decisions, it's something that we need to work very hard towards getting back the sense of pride in being a municipal manager, in becoming one, and saying that I really am in the position where I make a difference in the lives of the communities that I serve. Yeah, I often, I'm sorry, I'm going to digress a little bit, but you know, the word administration, I often ask people, do you understand what that word means, where it comes from, what the etymology of the word is? Now, administration comes from two Latin words, ad and ministere, and it simply means to serve. That's what the word administration means. And for all of us that are involved in administration, if we can go back to that service delivery ethos, to saying that I'm not here, if I want to become rich, go and become a business person, right? But if you work in local government, have that service delivery ethos, have that administrative ethos at the heart of what you do. And to the elected representatives, please allow us to do what it is that we're supposed to do within that very complex legislative environment that we work in. So that's my little bit of preaching about being a local government manager for now. I still am extremely proud of what myself and my colleagues are doing. There's a lot of good that happens in the, I'll call it a profession, even though it's not recognized as a profession yet. But there's a lot of good that happens. Unfortunately, as what happens often is that the negative parts get highlighted, right? That gets the play in the press and on radio and on TV. And in some way we need to showcase a lot of the good that happens, a lot of the good work and sacrifices that people make when they are in senior management in local government. We need to get to that point, I think. I want to, if I get to the next question on professional associations, I think there's ourselves, those that are involved in the profession, and our organizations need to do a lot of self-examination about what it is, the role that we play towards getting to the point where we can come to government and say, listen, this is the group, this is the organization that represents local government. I've been involved in the ILGM over many, many years. It's been my great honor to write the code of ethics of the ILGM many years ago. But, you know, we haven't come together in local government to say, you know what, ILGM, SIGFARO, all the different institutions, let's come together, let's create an umbrella organization so that all the different professions in local government can be represented by one organization. That's work that we need to do. If we come to the question of the role that a professional institution can play, I think firstly the whole question of certification. In other words, we need to have a body that is empowered to say person X meets the requirements, has the skills, the knowledge, the aptitude, because I think that's also important, right? And the ability to be at a certain level, to manage a municipality of a certain size, to perform the functions of a senior manager in whatever part of the municipality that is. So that's the first step. So then municipalities must be forced by law, I think, to recruit their senior managers and the municipal managers from the pool of people that are certified to you know, just like, you know, you have to be admitted as an attorney or an advocate to practice as a lawyer. I think we need to have local government managers admitted and certified that they are able to perform. So that's when you make appointments, and hopefully that will weed out some of the bad appointments that are made. But then a second thing, and ancillary to this, is the whole question of how sometimes politicians use what's the word I'm looking for now? The suspension of local government managers as a tool. You know, when a local government manager doesn't want to give in to the political pressure, then often suspension is used as a tool. Now, I think that the professional association can also play a role there to look at possible suspensions and make a determination and assist in saying whether there is actually a prima facie case for for suspension or not. I've made a proposal a few years ago. It didn't get any traction, I must immediately admit. And I hate using salary and money as a motivator for performance. But I'm wondering whether we shouldn't link the level of salaries that both senior managers and municipal managers, but also executive mayors and speakers and members of mayoral committees can get based on how they perform on a few 3, 4, 5 key indicators, you know. I mean, you cannot earn top dollar if you have audit outcomes that every year, you get qualified audit opinions, or you get disclaimers, but yet you earn the same as a person that gets unqualified audits with no matters. So I think we need to look at indicators like that. Spending of capital budget, for instance, you know, reducing the unauthorized, irregular, fruitful, and wasteful expenditure. So there are some indicators that I think we can use as a measure to determine salary levels, for instance, in local government. Then, in respect of the team not selected by you, I have never had the honor of selecting my own team in any of the municipalities that I've been the municipal manager in. That didn't stop us from performing. You know, when I got to Saldanha Bay municipality in 2001, it was after the first democratic local government elections in 2000. The team was there, but they were competent. So whether I selected them or not, that was not the issue. They were competent, so we could perform, and we performed very well. I've been used as an administrator in terms of Section 139 interventions in a few instances. And when I went there, you know, I inherited the team that was there, and I had to work with them, even in the situation that I'm in Knysna at the moment. You know, I didn't appoint the people that are here. So you can, if the process of appointing people is a proper process and you appoint competent people, then I don't think it's necessary. It's really necessary for the municipal manager to be able to select his or her own team, as long as the competence is there. And then you must deal, if there is incompetence, if there is not a level of service at the level that you require, you must deal with that. As a manager, you have the ability to deal with poor performance, and we must stop being scared of dealing with poor performance. We must deal with it. So for me, the question of appointing your own team is not really a big issue. Professor Steytler, if you'll allow me, I'll just want to say 1 or 2 things on the question of autonomy, because it's something that I've thought about quite a lot. And I agree with Cllr Nkadimeng that we've got what I call pseudo-autonomy in many instances in our municipalities, right? Many of our municipalities don't have the ability to be financially viable. So they get the money that for the budget they get from external sources, and mostly in the form of conditional grants. So somebody else tells you what to do and when to do it and so on. I often make the example of Laingsburg municipality being the smallest municipality and the city of Johannesburg. In our situation in South Africa, they both ostensibly have absolute autonomy. But I don't think that is the case. So this whole question of autonomy, I think we need to relook, we need to revisit. I quite like the Namibian example where, you know, municipalities go through a process of gaining more and more autonomy, the way, you know, on the basis of how they grow as institutions and are able to take on more responsibilities and autonomy. So we must probably look at that. I think some of what we have in our constitution was probably influenced by the euphoric moment of liberation in '94, and we need to go and revisit some of that. So automatic autonomy for local government. I'm going to get a lot of messages after this saying it's sacrilegious to say so, but I think that automatic autonomy for local government should not be there. We need to earn the autonomy if we have it. Thank you.
Thank you very much. You left us with a real issue to ponder, and it's obviously key. It's going to be key in the future when municipalities now become more and more dependent upon transfers to survive, and also how to get a better performance out of the money that they have, and that the Auditor General can start reporting a better turnaround, a better performance financially. Thank you very much to our panelists, but let me give the last word to Jaap to do the formal thanks and the closure. Over to you, Jaap.
Thank you, Nico. I'll keep it very brief because we are way over time, but that happens when, when we start talking local government and we get excited and the passion comes in and we have so much to say and so much to share that we go over time. But I think there's been a very frank, useful, constructive, interesting discussion. I've learned a lot. It's great when academics put a roundtable together and they are able to make contributions, but they're also proven wrong by the practitioners. This is great. This is what more academics should do. So thanks very much to my fellow panelists. Thanks to Hon Muthambi. Thank you very much for making time. I know you probably had a million other things that you could have been doing, so I really appreciate you sharing the panel with me. Cllr Nkadimeng, thank you. We've been on a few panels together right now, and I always enjoy sparring with you, so thanks again. Louis, Dr. Scheepers, thank you so much. I think your insights were fantastic, useful, from the heart and from the work floor, which is where in the end things happen. So thanks. Also thanks to the participants, thanks to the audience. We've recorded this session and we'll make it all available. You'll get the recording sent to you, and we'll also publish it on our internet site. Thanks for your questions. Thanks for your participation and your patience. I also want to thank people who helped us make this happen, particularly Mandy Cupido in the background, who looked after the logistics. Thanks to the Hans Seidel Foundation for sponsoring our efforts in this regard. Their support is much, much appreciated. And the two colleagues with which I was scheming to put this all together, Lance Joel of SALGA and Khadil Molaji of SALGA Western Cape. We haven't seen them, but they played a major role in putting this together. So thank you to everyone, and thanks to Nico for chairing so ably us through these 2 hours. And let's stay in touch and have a good weekend, everyone. Bye-bye.